Good afternoon, everyone, and welcome to Global Legal Group's latest webinar, Consumer Protection in Europe, Enforcement Trends, AI Regulation, and Cross-Border Compliance, held in partnership with the Association of Governance, Risk and Compliance. I'm joined by today's chair, Mateo Jarrin Cuvi of the AGRC, as well as our two speakers, Christopher Eberhardt, partner at Ashurst, and one of the contributing editors to the ICLG Consumer Protection, and Dr. Alexander Amann, founder and owner of Amann Partners, and co-author of the Austria, Liechtenstein, and Switzerland chapters of the publication. Today's webinar will explore consumer protection laws both in the UK and the EU, risks associated with the use of AI, greenwashing claims, and compliance programs. So, with that said, I'll now pass over to Matteo to get into the crux of today's conversation.
Thank you, Ella, for the introduction. It's nice to be here. Thanks, Chris and Alexander, for joining me here today. I just want to let everyone listening in, if you have any questions for either Chris or Alexander, please use the chat function on Zoom. For some reason, the Q&A function on Zoom was being a little finicky, so just drop the questions in the chat. I will be moderating the session, so I'll save those questions for the last 10 or 15 minutes that we have left towards the end of the session. So we have a series of 6 questions here. Before getting started, I'm going to ask both of our speakers to briefly introduce themselves, tell us a little bit about who they are, why they're so passionate about consumer protection, and then we'll take it from there. Chris?
Thanks, Mateo. Hi, everyone. Yes, my name is Chris Eberhardt. As Ella said, I'm a partner in the competition and consumer practice at Ashurst, based in London. I've been practicing for over 15 years now. Historically, had a focus primarily on competition law, but in the last 7, 8 years in particular, have been focusing on consumer protection. And that's essentially, as we've seen, to sort of foreshadow some of my remarks, we've sort of seen the growth of consumer protection enforcement in the UK. In particular with new enforcement powers, new areas of focus, and look forward to discussing some of those in the course of this session.
Excellent. Thank you, Chris. Alex?
Thank you very much, Matteo, and thank you for the invitation. As was said, my name is Dr. Alexander Amann. I'm the founder and owner of Amann Partners, Attorneys at Law. We're a law firm located in Liechtenstein and Switzerland. We represent clients, mostly harmed investors, aggrieved consumers in Liechtenstein and Switzerland, but also in Austria. We were especially active the last about 10 years in the Dieselgate case in Austria and in Switzerland, where we led the second largest class action in Austria and the largest and the only one in Switzerland. But we're working constantly on other such large-scale investors and consumer actions across these 3 jurisdictions. As you might have noticed, I'm basically 100% litigation attorney. So I will today be talking about the private enforcement side of things in the European Union predominantly, and I'm looking forward to the discussion as well.
Thank you. Excellent. Thank you for the introductions. So let's get started with the questions we have here. As I mentioned, if you have any questions for either of the 2 speakers, just use the chat and drop those there, and we'll take care of this towards the end of the session. So let's start looking at the latest developments in consumer protection landscape in the UK with Chris. And what changes were introduced by the Digital Markets Competition and Consumers Act, Chris?
Thanks, Mateo. Yeah, so I mean, as I hinted in my introduction, we've seen quite a significant shift in the consumer protection enforcement landscape in the last sort of 12 to 18 months. To sort of set the scene, there are a number of regulators in the UK that have consumer enforcement powers, the main one really being the Competition and Markets Authority, who's also our competition regulator. But also you have trading standards authorities, which essentially are units within local authorities responsible for enforcing a whole range of consumer trading and product legislation, as well as then sort of sector-specific regulators. So, the Financial Conduct Authority for financial services can enforce consumer law, and there are regulators again in telecoms and energy and airports, for example, aviation, have similar powers. Now, historically, despite there being a wide number and range of regulators, actually consumer enforcement in the UK was relatively light touch. And that's essentially because none of those regulators could find issue decision, investigate an issue decision, finding an infringement of consumer law. And they could not, as a result, there was no ability to issue fines for breaches of consumer law. All those authorities could do was essentially to, yes, investigate, yes, engage with companies or traders found to have breached consumer protection law, but then essentially their remedies were limited to seeking undertakings or commitments from those traders. And if that failed, the only recourse really was to apply to courts for enforcement orders, and the success rates actually were fairly slim. So the new Act for Digital Markets, Competition and Consumers Act that Mateo you mentioned already, that sought to change all of that essentially, and in particular for the Competition and Markets Authority, it introduced really significant changes to civil enforcement in the UK, in particular by introducing what we call direct enforcement. So that means that as of 6th of April 2025, last year, the Competition and Markets Authority can now and does now issue infringement decisions setting out findings of infringement against traders found to have infringed consumer law. So these decisions will set out the law, the facts, the evidence that the authority has relied on in establishing an infringement. And in particular, where it finds an infringement, it can now impose financial penalties. So it can impose fines of up to 10% of worldwide turnover on companies and up to £300,000 on individuals. And as well as fines, it can also impose redress requirements. So it can require companies to refund affected consumers. So what this has done essentially is made it a lot easier for the Competition and Markets Authority to bring these cases. It's no longer relying on the courts. It can bring these cases essentially of its own steam, and has really sharpened the teeth they have when seeking to enforce consumer protection law. And actually, we saw the first financial penalty and first decision issued in April this year. That was an investigation relating to 2 driving schools in the UK. The investigation related to drip pricing, which essentially is the practice of displaying further fees that a customer is going to have to pay as the consumer journey progresses, rather than showing all of those fees up front. Essentially, the CMA found that those driving schools had not included booking fees in the total upfront price given to consumers. That affected 80,000 consumers in total, and those driving schools were fined £4.2 million and ordered to pay refunds totaling £760,000. So that was just over £5 million, or just around £5 million of redress, essentially, in respect of that infringement. And it's worth saying, actually, that case was settled, and there was a 40% settlement discount. So absent that discount, the total fine would have been just over £7 million. So potentially quite a significant level of penalty given the number of consumers affected, and really does illustrate how that regime will work. I think we will start to see increasingly significant levels of penalties imposed for consumer infringements in the UK when they've just not been a feature of the regime before. So that's on the enforcement side. It's worth saying that the DMCC Act also introduced some substantive changes to consumer protection in the UK. Most of the law is unchanged, but there have been a few changes. So in particular, there were new banned practices in relation to fake reviews. So new practices now where, which relate to submission, commission, and publication of fake reviews. And we've started to see enforcement action around that. For example, the CMA did a sweep in July last year of, I think, just over 100 businesses, and found that just over half of those 54 were not complying with the new rules, and in particular not complying with the CMA's guidance. What the CMA has said essentially is that all traders who publish reviews or even review information on their websites, and review information can include things like those star ratings, reporting Trustpilot reviews or Google reviews that you see on quite a few websites. So even reporting that type of review information brings you in scope. And they expect all of those traders to have conducted, at the very least, a risk assessment to work out, are they complying with the rules and what the risk areas for themselves are? And then secondly, have a published policy on their website explaining their position in relation to fake reviews and the steps they are taking. And those 54 companies, all they had done was not publish a policy on the website. The CMA did not look into whether or not the reviews on their sites were misleading. The CMA was purely investigating, have they complied with that requirement now under the guidance to publish that policy. And then in March this year, it took things sort of a step further and opened 5 investigations in relation to fake reviews. And these intentionally, I think, covered the full range of the sort of the review ecosystem. So from collection reviews, publication reviews, how traders were treating negative reviews, whether they were being suppressed, whether incentives were being given for reviews, and also relating to those star ratings. So, a suite of investigations really going across the full ecosystem of those activities. Then the other key area of new law is drip pricing. I've mentioned that already in the context of the AA case. Essentially, the Act introduced a new unfair commercial practice under UK law relating to the omission of material information from invitations to purchase. And the Act says that the invitation to purchase, so essentially any time a trader is making an offer to a consumer to buy a product or take another decision, that will need to include the total price for that product, including any applicable fees, charges, taxes, or other payments. Or if you can't calculate the total price, enough information about how that price will be calculated. What that means in practice, and certainly for drip pricing, is that any mandatory charges, mandatory fees, mandatory taxes now have to be included up front. Doing what AA did and including those at a later stage is now prohibited. Focuses on mandatory charges, and that has generated quite a lot of debate about what's mandatory and what's optional. Optional charges don't need to be included, although any presented information needs to be given. But there's been a lot of debate about, when for a particular type of consumer can an optional charge or an inferior optional charge actually be mandatory. And I think that is an area we'll see further investigations. There are a couple ongoing. And then the final area of new law, which is not in force yet, but which will be coming in probably by this time next year, relates to subscription contracts. So these are auto-renewing contracts that renew for fixed or indefinite periods, essentially that renew until customers take action to end them. It also includes contracts that offer sort of initial free trials or reduced cost trial periods. And in about a year, the Act will have introduced quite extensive and quite onerous new protections in respect to subscription contracts. So there'll be specific requirements in respect of the information that traders are required to give up front in respect to those contracts, essentially making sure that consumers are aware of what they're entering into, what the minimum periods are going to be, what the pricing is going to be throughout the contract, and also what they need to do to terminate. New rules around cooling off periods. So currently there's a cooling off period when you first enter into the contract. Under these new rules, that's going to need to apply for each renewal. New rules in relation to reminder notices and end of contract notices. And I think in particular, new rules to allow easy cancellation. So the Act says that cancellation will need to be straightforward. And the example given, if you enter into a contract online, you need to be able to exit that contract online. We're still waiting for some of the specifics around those rules, but it's clear from the Act that when those come into force, there'll be really quite a significant set of restrictions on and obligations on those types of contracts. So I think those are the key changes we've sort of seen so far, Mateo.
Excellent. Thank you, Chris. Now moving on to the EU level with Alexander. What are some of the recent enforcement action and priorities there? And also, if you want to discuss some of the legislative initiatives, such as the Digital Fairness Act and the reform of the CPC regulation. Alex?
Happy to do so. Thank you very much, Mateo. So from my perspective as a litigator, obviously, one of the most significant developments, not only of the last 15 or 18 months, but of the last 10 years or so, was a strong shift towards private enforcement in regulatory and consumer protection matters. So historically, at least in the German-speaking markets in the European Union, including Liechtenstein and Switzerland, consumer protection and unfair protection from unfair competition practices was basically a task for consumer protection and trade associations. Under unfair competition laws in German-speaking markets was very heavily disputed and most of the time denied that there were any claims under the Unfair Competition Acts for the affected consumers themselves, but only the trade and consumer protection associations could bring claims, but not claims for compensation, but only claims for an injunction against those trade practices. This very much changed, especially with the Dieselgate case and with one of the leading judgments of the European Court of Justice, which was issued, but only in March 2023. So from the time the Dieselgate scandal became public in September 2015, it took us about 8 years until we knew whether and what types of claims affected consumers, affected car holders in the German-speaking markets have. And you might think, at least this is an old story, and at least by the time that judgment of ECJ in March 2023 was issued, the story must have been over. But exactly the opposite is true. The Dieselgate case, at least in certain markets, is more current than ever. In Austria, we're seeing references to the ECJ for preliminary rulings almost on a daily basis. I believe we have now about 200 or maybe even 300 cases referred by Austrian courts to the European Court of Justice about interpretation of the emissions regulation, interpretation on damages calculation, interpretation on the rules for the burden to prove certain aspects of the case, and for computation of interest. Now, the groundbreaking thing about that ECJ case of C100/21 QB against Mercedes-Benz of March 2023 was the holding, and it was a grand chamber judgment of the European Court of Justice. And it was the holding that even though the emissions regulation primarily serves and has the purpose to protect the environment, of course, and only a very minimal degree of the regulations or the provisions included in the emissions regulation even touched upon the topic of consumer protection of the car holder. Even in such a case where a EU regulation or any EU legislation for that matter serves to protect primarily other purposes, but might also have the purpose of protecting a consumer or a consumer making an informed decision. Any person, any consumer affected by a breach of such a legislative act of the European Union may claim for damages. And in this case, not damages against the seller or the reseller of any affected, any manipulated automotive, but against the manufacturer of a car itself. And this was a completely new thing. We had to argue fraud. We had to argue intentional deceit. We had to argue breach of good mores in order to derive a damages claim against the car manufacturer directly. And only with that judgment, it was established by merely breaking regulatory laws that even do not have the purpose of primarily protecting consumers. Affected persons can derive damages claims out of a mere negligent breach of such a EU legislative act. And this is a very groundbreaking thing of that ECJ judgment, because it made our position much stronger as against the car manufacturers themselves. But not only in the Dieselgate case, we see a very strong shift towards private enforcement, but we have investors' cases based on the concealment of kickbacks, unlawful processing fees in credit contracts, unlawful clauses or intransparent clauses in FX credit agreements, in cartel damages cases, lawsuits, large scale and masses of lawsuits against online casinos, especially in Germany and Austria. We have GDPR claims with values in dispute of in the individual case only 100 to small numbers of thousands of euros. We have medical device litigation in the German-speaking market. So you see a very strong shift towards private enforcement with the purpose of consumer protection, but also with the purpose of preserving fair market practices and combating cartels. So, and what you see moving from those general EU legislative acts that for some part have been more than a decade or decades old, such as the Unfair Contract Terms Directive or the Unfair Commercial Practices Directive, you see an integrated approach of several, especially newer legislative acts in the digital market space, protecting the market and the free competition as such, meaning protection against cartels, against so-called gatekeepers, that would be the Digital Markets Act. You see protection of consumers against certain trade practices of online platforms, that would be the Digital Services Act. Of course, you see data protection with the GDPR that is very well known. And the last couple of EU legislative acts are the EI Act, and let's see, it's the AI Act, and as Mateo already mentioned, the Digital Fairness Act, which is only a proposal and only in the legislative process, but it's basically an approach for an integrated consumer protection legislation based on regulatory and public as well as private enforcement of those new laws. What we also have, but what is maybe not the focus of my work, is the Consumer Protection Cooperation Regulation, which serves to increase the cooperation of certain consumer agencies across the European Union. And among those consumer protection agencies, there are trade or consumer protection, and therefore private associations as well. And this act serves to strengthen cooperation, therefore efficiency of public enforcement of consumer protection laws. But this Consumer Protection Cooperation Regulation is in the process of being adjusted and improved as well to increase effectiveness of both the substantive laws and the laws of enforcement.
Perfect. Excellent, Alexander. And thank you for at least setting the stage and telling us a little bit about both the EU and UK. So I think now we can go into, I guess, more specific items within each, let's say, jurisdiction or area. Of course, you can't get away with any webinar these days without discussing AI. So my next question is for Alexander. Looking at, what are the key consumer protection risks associated with the use of AI? And how are regulators responding to address the challenges associated with the use of AI? Alexander, you want to get started with that one?
Absolutely, I'm happy to do so. So I've already mentioned the AI Act, which is a regulation, a very current regulation of 2024. And it complements the other regulations or legislative acts I have mentioned as well, the Digital Markets Act, the Digital Fairness Act, which is in progress, the Digital Services Act, and the GDPR. And the main concerns that consumers face with, or the main risks that consumers face regarding AI are lack of transparency, lack of explainability, because many AI systems operate as sort of black boxes, making it very difficult for consumers to understand how decisions are being made. For instance, when it comes to credit scoring, loan approvals, insurance pricing, online recommendations, or recruitment processes. There might be a risk that AI software has some tendencies of discrimination and biases against certain genders, ethnicities, ages, disabilities, or for other aspects of a specific person or group of persons. Then, of course, but this is not only genuine to AI, but this has been an issue and addressed for decades already addressed by the Unfair Contracts Terms Directive, Unfair Commercial Practices Directive, manipulative and deceptive trade practices, for instance, personalized advertising, dynamic pricing, or recommendation algorithms that I believe Christopher was touching upon before. We have privacy data protection risks. We have safety product liability concerns, turning back to the Dieselgate case. Of course, back then we didn't have AI controlled cars, but as we see it now with the electric vehicles and self-driving vehicles, of course, there's a product liability and product safety concern as well. Of course, not only in the automotive sector, but in other sectors, any sector for that matter, where AI is implemented. And we have fraud, misinformation as some risk. You see that how very realistic those AI videos are made nowadays for the everyday consumer, basically non-conceivable whether this is an actual video or whether you're talking or chatting with an actual person, an actual investment advisor, or whether this is a chat bot, but a very sophisticatedly drafted or programmed chatbot. So these all are risks that might arise or might be aggravated by artificial intelligence. And as I already mentioned initially, the regulatory response of the EU lawmaker is a very comprehensive AI regulation called the AI Act. It's a regulation of 2024, and it adopts a risk-based approach on AI software and AI-driven products, prohibiting certain AI practices, such as manipulative AI that significantly distorts consumer behavior, AI that is designed for exploitation of vulnerable groups, such as children or persons with disabilities, and other similar AI practices. Then you have another layer of high-risk AI systems. And one of the best examples, I believe, is AI-driven products that are regulated themselves, such as in the automotive sector or in the medical product sector. There you tend to have high-risk AI systems, which are subject to regulation and subject to certain risk management measures, human oversight, data governance standards, transparency obligation. And throughout the Act, you can see that there is a need for AI software product providers for transparency requirements. But the mere fact that there is now a very comprehensive AI regulation designed, and there I'd like to touch upon the point that I mentioned initially. You can nowadays derive damages claims as a consumer, as an affected party, even when a certain regulation does not have the purpose of protecting primarily the consumer, but has the purpose of protecting the environment or any other aspects of life. Here, the AI Act specifically has the purpose of protecting both consumers and companies. But that isn't to say that the other acts that are already in place, such as the Unfair Commercial Practices Directive, Unfair Contract Terms Directive, and all the case law of the ECJ that has been issued so far on these already existing laws, that isn't relevant anymore. But the AI Act is there to complement already existing market regulations, such as Unfair Contracts Terms Directive, Unfair Commercial Practices Directive, such as cartel rules, such as the GDPR, the DSA, and other such acts.
Excellent. Thank you, Alex. Chris, anything from the UK perspective when it comes to AI?
Yeah, so I mean, obviously, it's been as you've been expecting. We would expect it's been an area of focus, but a slightly different approach in the sense that what we haven't got is sort of government regulation or new law in connection with AI. But it's certainly fair to say that the regulators are looking at how the existing consumer protections and the other protections that are equivalent to the other sort of legislative acts that Alex has mentioned, would apply. There's been in particular a lot of focus, drawing some of the themes that Alex has said around the extent to which AI worsens the potential impact or detriment that consumers may suffer in cases like manipulation or bias or lack of transparency. And what the CMA has said in it so far is that any traders that are using AI as part of their consumer journey really have to bear in mind that using AI does not get them off the hook. But if they are using AI, they are responsible for that AI in exactly the same way as if their own employee was interfacing with businesses. Now, what does that mean in practice? Well, it probably means that actually, if you're using AI agents, they need to be trained on consumer protection law. They need to know what their own limits are if they're interacting with consumers. It means that needs to be monitored. You can't just implement an AI and let it run. And it also means that you can need to be really transparent with consumers and make sure they are aware about when they're talking to an AI agent versus when they're talking to an individual. So there's no law yet, there's no cases yet, but there's a lot of thinking about how those types of issues could arise and how consumer law could be used to address them.
Excellent. Thank you, Chris. Now, shifting gears a bit, let's look at greenwashing. And Chris, you can get us started with this one. But the question is, as businesses continue the drive towards net zero and sustainability targets, greenwashing or misleading green claims has clearly become a priority area of enforcement for regulators worldwide. What are the key enforcement trends in this space coming from the UK?
Yeah, sure. So, I mean, I think across Europe, really, this has been an increasingly, growing area of focus. So, in the UK, unlike the EU, and this is an area where we're seeing divergence, which we might come back to, there are no specific prohibitions against greenwashing. So, it's dealt with again under the existing, consumer protection landscape around unfair practices, misleading acts, and misleading emissions. But again, that does not mean there's not been guidance. It does not mean there's not been enforcement. So, the CMA, I think 5 years ago now, 5 years ago, published what's called its Green Claims Code, and that essentially sets out 6 key principles. I think 6, counting through them, 6 key principles that it says should govern how traders are communicating or making environmental claims. Those 6 are, claims must be truthful and accurate. So traders should not be giving consumers the impression that their product, their service, their brand is more environmentally friendly or more sustainable than it actually is. So they will look at things like, broad claims, general claims, language such as calling things just green or sustainable or eco-friendly without any justification, any substantiation can be found to be unlawful. And they'll look at the overall presentation, it's not just the words you use, it's the images, the pictures, the nature of the presentation, the claim you're making to consumers. Claims must be clear and unambiguous. They should be worded as transparently and as straightforwardly as possible. So avoid using vague claims, overly generic claims, complex claims, look at the ordinary meaning. Claims should not omit or hide important information. So you can't just focus on the positive aspects, but ignore potential negative impacts. And this is something actually that in the UK, the ASA, the advertising agency, which I'll come back to, has focused on energy companies for. There are a series of rulings where they've said to energy companies, yes, you can make claims about your environmental investments and how you're investing in new technologies, but in doing so, you can't omit the fact, if applicable, that you may still be investing in fossil fuels or carbon intensive. You need to show the overall picture, the overall transition. You can't just focus on one aspect. Any comparisons must be fair and meaningful. So make sure you're comparing like with like. A real key focus on considering the full life cycle. So if you're making a claim about an environmentally friendly product, that needs to make sure that the full life cycle of that product meets that claim. So if we're talking about a plastic bottle, and you're saying it's recyclable, does that apply to the bottle? Does it apply to the label? Does it apply to the cap? That's something Coca-Cola fell foul of, fairly recently. If you're talking about a supply chain, that raises all sorts of questions about, which elements of the supply chain do you include? Which elements of the supply chain need to provide verification in respect of claims? What sort of information do you require? And that ties into the last principle, which is that all of those claims must be substantiated. So traders should be making sure they've got robust, credible, relevant, up-to-date evidence, and they can really make sure they can substantiate those claims. Now, those are the principles. We've seen some enforcement action, not under the new rules. So we haven't seen decisions, we haven't seen fines, but we have seen undertakings. So 2 years ago, the CMA accepted undertakings from 3 online fashion retailers, essentially around the claims they are making about brands, collections of fashion products that they claimed were environmentally sustainable or more environmentally sustainable than others. And they offered undertakings essentially as to how they would treat those going forward. And then the final piece I'd mention in the UK is the role of the Advertising Standards Authority. So for those who don't know, the ASA essentially is the industry body responsible for upholding agreed standards, agreed principles in respect of ads. There are various advertising codes that they oversee. They don't enforce because they can't issue penalties, but they can oversee the codes and they can apply the codes and issue rulings. And they've had quite a significant focus on environmental claims over the last 3 or 4 years. Their codes have particular rules relating to environmental claims. Those basically mirror the key principles I've been through, so I won't go through those. But if you just look in 2025, I had a quick look prior to this webinar, I think that I counted at least 10 rulings against adverts, in particular because those adverts were found to contain misleading green claims. And they look at a range of sectors across that: airlines, retailers, energy companies, car companies. There's been a range of sectors that have been affected. So I think that's mainly what we've been seeing in the UK.
Thank you, Chris. Alex, anything to add from the EU perspective?
Well, again, since I'm working for more than 10 years now in the Dieselgate case, and this is basically something about green claims being made when in reality the car manufacturers were not even able to comply with the regulatory minimal standards, let alone being especially economically friendly. But at that time, specific regulation, at least on an EU level, let alone on a national level, did not exist. We were, as I mentioned initially, bound to apply general rules of misleading trade practices. But But of course, that was always an argument of ours that they're not only violating the minimal standards called for in the emissions regulation, but they're also misleading in the sense that even if they were to comply with the minimum standards, they're not advertising their cars or their products as merely complying with minimal standards, but they were advertising their cars with slogans such as Blue Motion and other such brands or trademarks or slogans that indicated that they were better than this minimum standard, and thereby misleading customers and selling overpriced products that have a minor quality. So this was our argument all along. But nowadays, of course, we're seeing specific regulation at an EU level. As I found in preparation, there's apparently been a proposal for a green claims directive. There is already a directive of 2024 of the European Parliament and the Council regarding, and I'm just mentioning the title here, regarding empowering consumers for the green transition through better protection against unfair practices and through better information. So it's protection of fair market practices and of consumers through information and transparency.
Excellent. Thank you, Alexander. Now let's move now a little bit towards the more practical item of the webinar and looking at some of the key elements of an effective consumer law compliance program. Chris, I guess you could start with this one. But the question is, what are the key elements of an effective consumer law compliance program, and how can businesses ensure that compliance is effective and embedded throughout the organization? And Chris?
Sure, thanks. So, look, I think first comment I'll make is, given all of the significant changes we've been talking about, then I think having robust compliance systems in place clearly has never been, more important than it is today. That's sort of general point one. General point two is that I think, as ever, compliance is not a one-size-fits-all solution, right? For each business, depending on the risks they face, the activities they're engaged with, the sectors they're engaged with, each business needs to look at its own compliance in terms of what's appropriate for it and its business and the world it faces. But I think there are a number of sort of elements of what at least we would advise as being an effective consumer law compliance sort of program. The first, which relates to it not being a one size fits all, is to do that risk assessment. So identify the highest risk practices, identify the areas in consumer-facing materials, consumer-facing interactions, consumer terms, which are likely to raise concerns, likely to raise regulatory scrutiny. Keep in mind all of the enforcement areas that we've been talked about and that you're seeing that regulators are looking at, and be sort of in particular focused on those. And obviously that's an iterative process that needs to be kept up to date. Marketing copy, consumer interaction materials, they're constantly changing. And I think the business challenge many businesses face is how to make sure that they're keeping up to date and ensuring that as there are new changes, those are compliant. So once you've got a handle on those risks, where your sort of risk areas are, it's really about having appropriate policies, procedures, guidance, and training in place, making sure that you're clear internally what your red lines are, what the risk areas are, and what your internal policies are. And that needs to cover both the output, but also the mechanism to get there, in terms of the procedures to review copy, to procedures to review claims and make sure they are compliant. And all of that really needs to be underpinned by clear governance and clear accountability. Regulators increasingly look for this. They want to see what they often call the tone from the top. They want to know that compliance initiatives are led from the very top. So making sure there is ownership at a senior level, board level visibility, that's increasingly important. And actually, from in the UK at least, in the world where companies could be facing fairly significant fines, up to 10% of worldwide turnover potentially, I think having that senior stakeholder oversight and visibility is never more important than it has been before. And that tone from the top doesn't just stop at the top. This needs to be embedded really throughout the organization. So I think increasingly there's a practice of thinking about how compliance can be integrated from the outset, really, into product and surface design. There's a lot of focus on the design of user interfaces. AI will only serve to sort of increase the complexity and the potential risks there. So really think about how you can ensure compliance from the outset. Thinking about monitoring and testing. I mentioned the CMA doing sweeps, regulators around the world, and they often do this on a coordinated basis. We see this in Europe and we see this internationally. We'll be doing sweeps of websites to look for particular practices. So quite often companies may think about doing their own mystery shopping, trials, conducting their own consumer journey audits, trying to find those risk points, and ideally trying to find them before the regulators do. Managing your third parties, managing your suppliers. We talked about this in the context of green claims. It's also an issue in the context of reviews where you're taking review information from third parties, but making sure you've done sufficient due diligence and have got sufficient procedures in place to make sure the information you're getting from your suppliers is accurate. And then I think finally, hopefully it doesn't go wrong, but when it does, making sure you've got that sufficient incident response and escalation procedure in place. Making sure that issues do get flagged internally, you've got procedures to address them, and then you can consider whether appropriate engagement with regulators or bodies may be necessary. But those are some tips. I think that the issue is that that's always changing. The risk environment is always changing. The developments are always changing. So all of that needs to be done alongside keeping a really close eye on what we're seeing and making sure you're responding to developments as they arise.
Excellent. Thank you, Chris. Alex, anything to add from your end?
I believe I would very much agree to what Christopher said, and I would only add that from the perspective of a business, I would not only look at the liability risk towards regulators, risks of fines and criminal prosecution, maybe even, but I'll also assess civil liability risks because they seem to become more and more significant across the European Union market.
Okay, excellent. Thank you for that. To everyone listening in, we have a question left. So before I actually pose that question, if you have any questions for either Christopher or Alexander, please drop them in the chat, and we should have 5 minutes towards the end to take care of that. So make sure you drop those questions before we wrap up. So the final question we have here, and Alex, you can get us started with this one, is, are regulators taking a coordinated approach to consumer enforcement across jurisdictions? And what does this mean for multinational businesses?
I mean, we were already talking about the Consumer Protection Cooperation Regulation. It's an EU regulation from 2017 that especially served the purpose for regulators across European Union member states to cooperate with one another and thereby making the substantive laws, consumer protection laws, regulatory laws more effective. So at least the purpose of the law is cooperation between the authorities, between the regulators in the various member states. There are indeed some examples for that. For instance, under the Consumer Protection Cooperation Regulation, some work has been, or proceedings have been ongoing in relation to third-party online platforms such as AliExpress and Wish since 2021. There, the Netherlands Authority for Consumers and Markets, they obtained, or led by the Netherlands Authority, the regulators in the several markets in the European Union obtained commitments from both platforms to align their practices with EU consumer law. As another example, in May 2024, the Bureau Européen de l'Union des Consommateurs, the European Consumer Organization, filed a complaint with the EU Commission alleging a breach of the Digital Services Act, DSA, by the online platform Temu. And this was joined by 17 national consumer protection organizations who filed the very same complaint with their respective consumer protection authorities in their various member states. So it very much looks like the practice is moving towards where regulators in cartel and antitrust law were operating for several years or decades already. And having in mind the very current Representative Actions Directive, where qualified entities are now entitled to file representative actions, not only on injunctions, for injunctions, but also for compensation in the various member states and the cross-border lines. It seems we're very much moving towards a very integrated network of consumer protection through regulators and through private enforcement, both by representative actions by qualified entities, which are generally the consumer protection associations located in the various member states, and through individual actions offered by private market participants on plaintiff's side, of course. So there we have regulators, we have consumer protections associations, and we have individual actions, forming sort of an integrated network of enforcement of consumer protection laws nowadays.
Thank you, Alexander. Chris, anything to add from the UK and how they are treating these cross-border sort of enforcement actions?
Yeah, just a couple of comments on what Alex has said. I mean, firstly, just picking up on the CPC regulation, because and I've heard, I think one interesting features of that could be that the Commission itself might be seeking consumer enforcement powers. And I think if that proves to be correct, that will quite significantly sort of change the enforcement landscape, certainly in Europe. But I think how consumer protection is enforced globally, if you get that type of regulator really stepping up on consumer enforcement, I think that's a proposal, but let's wait and see if that happens. Obviously, the UK is no longer part of the European Union CPC regulation, so it isn't involved in those activities that Alexander has mentioned. There are broader international organizations that seek to achieve the same effect. I think the main one is ICPEN, forget what it stands for, International Consumer Protection Enforcement Network, I believe. And that sort of similar to the CPC, but without the sort of the enforcement toolkit, really seeks to coordinate the work of agencies really around the world. I think the Australians are very active in that, the US agencies, increasingly South American agencies, Japan is increasingly active. And the reality is for multinational businesses is that many of these regulators are looking at very similar themes. Yes, there may be nuances in terms of individual laws and individual practices, but certainly if you're looking at online safety, if you're looking at online choice, if you're looking at AI, a lot of the themes, a lot of the issues that consumers are facing are going to be very similar. And I think the agencies are increasingly aligned to that fact, and increasingly aligned to the fact that certainly in the UK we probably can't do it alone, that you need to be doing it on a coordinated basis and making sure that these rules are applied as best you can globally.
Excellent, thank you.
Maybe one more aspect,
because
ahead. Mateo, you were asking for what does that mean for the businesses, for multinational businesses, and from the perspective of a litigator, it seems that for businesses you also need to have that sort of integrated approach, having an overall strategic plan set up by let's say a central or core external law firm, litigation law firm that sets up the plan and obtains legal opinions from the certain or the several member states, at least in the European Union, or if you want to look at it on a worldwide basis, from the various jurisdictions and the various markets, to have sort of a cross-border view of what could happen and what you need to do to counter potential actions, but also to have an in-depth view of what is happening in various member states.
That makes sense. Excellent. We have 5 minutes left. Doesn't seem like anyone in the audience has any questions, so I think everything presented must have been crystal clear. So that's good to know. Or people they heard everything they need to hear from both of you. So thank you for that. Just one final question to wrap up. I mean, one like you have some concluding remarks or any sort of parting thoughts, or like the one thing that you believe audience members should leave this webinar with, just sort of as a wrap up in the next 2 or 3 minutes. Chris?
I mean, I guess from my perspective, I've talked about the new regime we've got in the UK, some examples that we've seen already, but that's a year in, and it's really only just ramping up. We do expect really quite significant levels of enforcement to continue. CMA has been fairly clear that it's got its new powers. It wants to be seen to be used, and it wants to be seen to be seeking enforcement. It is also focused on engaging with businesses, and I think that's welcome. But we do also expect there to be enforcement. So I think businesses operating in the UK need to be mindful of that risk and make sure they are implementing the compliance steps to try and minimize those risks, because they're only going to increase as that regime sort of continues to bed in and the CMA continues to take forward its processes. Then I guess for me, AI is the area. I mean, it's sort of a bit trite now. We've covered it a few times, but commenting on looking at how AI is going to impact the consumer interaction, impact the consumer journey. I do think of all the areas, that's the one that we're watching closely to see how that's going to play through. And inevitably there will be issues, inevitably there'll be risks that arise, and it'll be interesting to see how, certainly in the UK, the regulators look to tackle those.
Thank you, Chris. Alex?
I believe one of the main takeaways from my experience is, and that might help businesses going forward, having a realistic view on liability risks. We were talking for years and years on how to calculate and assess damages in various different scenarios, not only in the Dieselgate case, but also in data protection cases. What is the risk of a personal, or what is the damage, the financial pecuniary damage of a personal data being stolen, misappropriated? And it seems like especially having in mind the principle of effectiveness, which is a very strong principle in the ECJ case law, and it was one of the underlying principles coming through that leading case that I was talking earlier. Not only does a consumer have to have a damages claim, but it basically cannot be zero, because that wouldn't comply with the principle of effectiveness. If there is a damage, consumers need to be able to claim them, and it needs to be sufficiently easy to allege, prove, and enforce those kinds of claims. So realistic assessment of damages by outside litigation counsel, I think that is one key takeaway of the developments of, I would say, the last decade.
Excellent. Thank you. Thank you, Alexander. Thank you, both of you, for your contributions. Hopefully the audience has left with plenty of food for thought. I'm gonna, I think, hand things over back to Ella, who is gonna say goodbye to us on behalf of GLG. So thank you very much, and look forward to staying in touch.
Thanks, Matteo. And yeah, thank you both for a really good discussion. If you're interested in reading the most recent edition of the ICLG Consumer Protection, you can find it at iclg.com. And we will send you a digital copy after the webinar as well. But thank you again, all. It was fantastic to listen to.
Thank you very much for the invitation.